Thank you, Rajeshwari, for that introduction. Good afternoon, everyone. I will be talking about, as Rajeshwari mentioned, strategic use of options, particularly the inter partes reviews in the United States. It's really surprising to me that how much interest is there with respect to the market in the United States, and I think maybe it shouldn't be that surprising given that 30% of the exports of many Indian generic companies are to the United States market. So that's the market that I'll be focusing on. Great, thank you. All right, so, wrong way, sorry. So the thing with the United States market is that it is very much winner takes all in terms of the pharmaceutical market. As you know, there are no average outcomes. If you look at the research-based pharma, once they are able to obtain approval for a new drug, they have a monopoly for a long period of time, almost 20 years from the date of filing, and then you add the patent term extensions, and it can last for a while. Not only that, there are no price controls. If you look at the sort of the pricing of pharmaceutical drugs in the United States, many of the CEOs of these companies, research-based, will tell you that they price their drugs based on the benefit the drug provides to the person who's taking the drug. Well, if it's a cancer life-saving drug, the benefit is tremendous, so the prices could be extremely high. And so in such a market, you know, the United States, as you know, created this Hatch-Waxman Act, and the idea was to create a situation where the generics could come in and challenge the research-based pharma's patents so that the generics could enter the market and lower the drug price. So that was the idea behind the Hatch-Waxman Act. And the idea, and there was an additional incentive, obviously, this 180 days of exclusive right to co-market the new drug. And that was the thought that if you could do that, then there will be an incentive for the generics to come in. Now, the point that I want to make is that with respect to IP strategy in the United States, you can learn from what's known as asymmetric or options in general. So an option is a broader term. It's not just a legal term. It applies to a situation where there can be an asymmetric outcome with respect to your investment. So for example, a simple option could be that if you know the downside, so if your downside is fixed, say it's the legal cost to challenge a patent, but the upside is asymmetric in a sense that you would capture a large percentage of the market, or if you're the second mover, and you'll have a 180-day sort of co-exclusivity with the research-based pharma company, or you could settle with the research-based pharma company, and that could also result in huge, big win or huge gains for you. So that's the point that I want to make with respect to asymmetric options. Now, one of the things that's happening in the United States, as we know, some of the people here have talked about earlier, maybe in earlier panels, is this evergreening of patents. So the notion is that once the patent on the new chemical entities expires or is about to expire, these research-based pharma companies get patents that are sort of secondary patents. They could be, for example, purity patents, dosage patents, and even flimsier patents like this speckled coating patent. And I actually have copies of this New York Times article from not too long ago that discusses some of these. So if some of you want a copy of that, please stop by after the panel discussion is over, and I'll be happy to share that with you. So how is it an asymmetric option? Is that if you could use the new procedures that are available in the United States now to challenge patents post-grant, that is the inter partes review, to me it's a good example of an asymmetric option. The cost of challenging a patent at the PTAB, as it's known, the Patent Trial and Appeal Board, where you will file your IPR petition, is not that high. It's compared to the cost of litigation. So it's not going to blow the budget, but it will give you a great settlement tool aside from your defenses and other arguments that you could advance in the ANDA litigation. So with that in mind, I want to talk a little bit about the IPRs, and then I'll come back to the pharmaceutical industry. If you look at the number of IPR petitions filed by month since the about 2013 March, there has been a steady increase in the numbers, and they've pretty much gone up every month. Now, if you look at the IPRs by technology areas, the biggest area is the electrical computer area with 49% of the IPR petitions, and the biopharm is the purple one, and about 17% of the petitions are in that area. And these are inter partes reviews filed in the United States Patent and Trademark Office. Now, this is again a graphic, and these are all from the U.S. Patent Trademark Office report on fiscal year 2015, which ended in August last year. And so, takeaway from this is that about 72% in 72% of the cases, if you look at that, the orange thing at the bottom, the 453 trials. So 630 trials were completed. That's the block above the bottommost blocks. And 453 out of 630 translates to 72%. So 72%, in 72% of the trials, all claims that were instituted during the IPR proceeding were found unpatentable. 72% of the cases. In 14% of the cases, that's the next block, 91 trials, some claims were found unpatentable. And only in about 14% of the cases, none of the claims were found unpatentable. So the success rate for the petitioners at the IPR petitions is pretty high. Now, this is another graphic that I don't want to really spend too much time on it, but you'll get it as part of the presentation slides. Let's move on to the pharma bio IPRs now. So this is the data on the pharma bio IPR filings starting with September 2012 when they became available for the first time on to July of this year. And you can see that the numbers have gone up, but not to a level where at least I would have expected. It's still about, the peaks were only about 20 per month in certain months. They're more closer to about 10 or so per month in terms of the filing rate. If you look at the top petitioners, these are probably very familiar big generic companies like the Apotexes of the world and Mylan and others. So those are the top petitioners. Apotex has filed over 15 petitions challenging patents at the USPTO through the PTAB process. And I put only those challengers who had filed at least, or petitioners who had filed at least 3 petitions. Dr. Reddy's and Ranbaxy had filed 2 each. So they didn't make the cut on this because I had the 3 as the minimum number of petitions, but they have filed, I think, 2, or maybe have filed more now. This is current only as of June or July last year. Now, if you look at the patent owners, this is the data on the patent owners. These are the patent owners whose patents have been challenged at the IPR, through the IPR process at the Patent Trial and Appeal Board. And so you can, again, see some of the players like Novartis and others whose patents have been challenged at the PTAB. Now, the reason to file at the PTAB is that you have 2 benefits. One is that one relates to how the claims are construed. So in the district court litigation, when you file an ANDA and somebody sues you after you file the ANDA, the claims will be construed under the intrinsic evidence standard. But in the PTAB, the claim construction standard is broadest reasonable interpretation. So it's a broader construction of the claim terms. And the second thing is that in the district court, to invalidate a claim, you have to convince the jury by clear and convincing evidence. But at the IPR, preponderance of evidence is sufficient. So it's a lower evidentiary burden in the PTAB proceedings. So in that sense, there's an advantage there. Now, what I wanted to talk briefly about is this one case called Cubist Pharmaceuticals v. Hospira that came out in November last year. And so this case to me illustrates sort of, how you could use obviousness as a basis to challenge patents at the inter-parties review process and take out those downstream patents. So in this case, there were, the drug at issue was this thing called daptomycin, sold under the name Cubicin. It was patented by Lilly originally. And then Cubist Pharmaceuticals started marketing that drug. And they had two types of patents at play, dosage patents and purity patents. So the dosage patents essentially recited methods of administering this drug in dosages, certain dosages. And the idea was that these dosages helped reduce the skeletal muscle toxicity, and that was apparently the novelty. So when it went to the Federal Circuit, the district court had already found these dosage patents invalid based on prior art. And the analysis was essentially based on the fact that there was prior art that showed the range of dosage, and there was no mention in the prior art about the minimizing skeletal muscle toxicity. But as you will see later, Federal Circuit's point of view was that, first of all, Cubist Pharmaceutical, that company, they did not discover daptomycin. And also the particular article, the prior art article, the Woodworth article, pointed to the use of this daily administration. So the idea was that 4 to 6 milligrams had to be administered on a daily basis, but that was mentioned in the article. And so then what Cubist tried to do was Cubist tried to point to the secondary considerations like unexpected results, market need, commercial success, and the Federal Circuit wasn't convinced on any one of those bases. So they basically upheld the district court's judgment of finding the dosage patents invalid based on the fact that they were obvious based on the art, like Woodworth article, and the inherent properties of daptomycin. I think that's a very important argument to make. So if you are thinking of using IPR process to challenge a patent such as a dosage patent or a purity patent or anything like that, particularly, it's important to have experts who can prepare reports and create a record that goes into the inherent properties of the drug as well for such downstream patents. Now, with respect to the purity patents, what was interesting was that the creative patent attorneys for Cubist had claimed very specific purity ranges. So, for example, claims were recited methods of preparing daptomycin composition that is at least 93% or 97% pure. So these were like specific ranges that they had claimed. Now, during the district court trial, the district court focused on the fact that the specification of the patent only talked about two purification steps, the aggregation filtration and the anion exchange chromatography. And so what happened was that the prior art talked about those steps. I mean, these were well-known, well-understood techniques. There was a publication that talked about the micelle filtration and also known as aggregate filtration. So Federal Circuit's analysis was that because those two techniques are the only techniques that are disclosed in the patent, and those techniques are in the prior art, the fact that there are some specific ranges of purity doesn't mean, is not enough to clear the obviousness hurdle, because that's the purity level that you'll end up with if you were to use those techniques. So I think that was a very interesting point of view. At least I found that very interesting, that they would go that route. So now, having given you sort of the one case, I thought I'll also give you a possible candidate that you could use to explore this asymmetric option opportunity. There is a pharmaceutical composition and this is not a case, by the way. This is actually a drug that's patented, that's sold in the United States and it costs about $7,000 or $8,000 per year for this drug if you don't have insurance coverage. And this is a composition that has an active pharmaceutical ingredient. There's a wetting agent, and then there is a non-volatile solvent of some kind. And the claims, the API is known in the prior art. The wetting agent is known in the prior art. The use of a wetting agent and a non-volatile solvent to increase penetration into the skin is known. There is now the issue is, based on what we discussed earlier and based on this Cubist case, I think this type of drug patent is very much susceptible to challenge. File an ANDA and be ready to file the inter partes review petition as soon as possible, and then use the leverage created by the IPR petition to negotiate a deal. So I think that's
Ranjeev, we're short of time.
Yeah. So that's all I got. I do have, by the way, a book that talks about asymmetric options and has some very good, interesting other things in it called Anti-Fragile. After, if you can tell me which drug do you think it is, I'll give you 4 options. And if whoever comes with the right answer, you get the book as a prize. Now, I just written down those 4 options, so let me get this, and then I'm done, basically. If you can find the slide with those 2 options that I'd written down, then I can wrap it up. Okay, so the options are, is it Axiva, A-X-I-V-A, Crestia, C-R-E-S-T-I-A, Ortaza, O-R-T-A-Z-A, or Jublia, J-U-B-L-I-A. Those are the 4 options. Whoever comes with the right answer later, I'll give you the book as a present as a result of your success. Thank you very much for letting me talk to you. Appreciate that. Thank you.